respondents conduct the presidential election held on the 26th of October 2017 in conformity with the Constitution and the applicable laws. Number 3, what is the legal effect of the withdrawal of a presidential election candidate before election? Did any of the candidates validly or properly withdraw from the presidential election held on the 26th of October 2017? Number 4, did the election conducted on the 26th of October 2017 meet the constitutional threshold of a free and fair election under Article 81 of our Constitution? Number 5, what are the legal consequences of not holding a presidential election in each constituency as required by Article 138(2) of the Constitution? Number 6, was the presidential election held on the 26th of October 2017 marred with the illegalities and irregularities? If so, what are their effects on the validity of the election? Number 7, what is the effect of the Electoral Law Amendment Act 2017 on the conduct of the presidential election held on the 26th of October 2017? Is Section 83 of the Elections Act as amended unconstitutional? Number 8, was the election held on the 26th of October 2017 and its results legitimate and credible, both in fact and in law? And lastly, what orders should the court issue, including orders on costs? So we have divided how we are going to read the judgment. We are not going to read every bit of the judgment. The judgment runs to more than 200 pages. So we are not going to read every bit of the judgment. Instead, we will, each of us is going to read, to summarize some of the issues and go on. Perhaps before we start, I would like to indicate that we had determined some applications which arose in the petitions. And we said that the full rulings on those applications would be delivered later. Those rulings are now ready, and I would request that the parties get copies from the registry rather than reading them here, because you already know the outcome of their outcomes. So please get the written copies from the registry. So at this stage, I would like to request the Honorable Justice Lenaola to read the judgment in respect of issues number 1 and 2, as I have outlined above. Justice Lenaola.
Thank you, Chief Justice. Issue number 1 is on the petitioner's locus standi. This issue of locus standi was raised by the third respondent at paragraph 14 of the response to petition number 4 of 2017. It was contended that the petitioners are not entitled to file a petition under Article 143, as the persons contemplated in the said article are not persons who have exercised their rights under Article 38. Subsequently, the third respondent's counsel submitted in court that the petitioners had only demonstrated that they were registered voters but failed to demonstrate that they had exercised the right to vote. Hence, they failed the test for filing a petition under Article 141. They argued further that participation in an election gives a person locus standi under Article 141, and that a person must have exercised the right under Article 38 to attain the locus standi. That is a question. The finding is as follows. Looking at Article 141, and Article 260 of the Constitution, locus standi to file a petition was addressed partly by this court in the matter of the principle of gender representation in the National Assembly and the Senate, advisory opinion number 2 of 2012, and the court said, Article 141 of the Constitution provides that a person may file a petition in the Supreme Court to challenge the election of the president-elect within 7 days after the date of the declaration of the results of the election. It is clear that the aggrieved in such a case may be a candidate in the election or indeed any other person. Guided by the terms of Articles 40 and 260, as well as the above cited pronouncement, it can be concluded that a person under Article 140 of the Constitution includes both a natural and a juristic person. There is no requirement for participation in an election under Article 140. The third respondent did, in our view, effectively affirm his submission to the effect that Article 141 bestows locus standi only upon persons who have exercised their right to vote under Article 38. Therefore, we hold that the petitioners have the legal standing under Article 140, sub-Article 1, to file the petition. The second issue to be addressed in issue number 1 is whether this case is one that falls under public interest litigation. The second and third petitioners at paragraph 2 of petition number 4 stated that the petition was considered in their own interest and in the interest of the public, pursuant to Article 258 and Article 22 of the Constitution. The first and second respondents did not respond to the issue of public interest litigation, but the third respondent in his response to the petition at paragraph 4 contends that far from advancing any public interest agenda, as alleged in the petition, the petitioners come as no more than surrogates, agents, and mouthpieces of the then fourth respondents and its leaders, and they masquerade as bona fide defenders of the public interest. Having looked at the law, including the Supreme Court of India case for Ashok Kumar and Mumatemu and Trusted Alliance Society, we have held as follows. We would have no doubt that the subject matter of the petition before us does meet the criteria to be characterized as being category public interest litigation. Public interest litigation is a public right under Articles 22.1 and 258.2c of the Constitution. It is a veritable vehicle for the vindication of public rights, such as extend beyond the constraints of common law doctrine of locus standi. Since public interest litigation, as it sounds currently, has elicited considerable judicial insight from the High Court, this is not the time, in our view, for this court to lay down hard and fast rules or guidelines for the admittance in relevant cases as we should, and therefore we cannot constrain the creativity of other superior courts. The general guiding principle in public interest litigation should always be that the suit must be brought in the broad public interest. It should not be a veil for private, commercial, partisan, or other non-public interests. The detailed contours of the applicable law will continue to unfold through the works of the superior courts. We would regard the preparation of such issues as symbolic or parties aggrieved and as presenting a real cause for judicial resolution. Issue number 2, the question of non-compliance with the Constitution as regards nominations. The petitioners have posited that without adhering to the law regarding nomination of candidates prior to a fresh election under Article 143, that edict regarding nomination would not have been complied with. The question that we pose, therefore, is why nominations a necessary part of the fresh election? In addressing the question, we decided to rephrase the issue to three sub-issues. The first sub-issue is, what is the purpose of nominations in a presidential election? Number 2, should the first and second respondents have conducted nominations of candidates in preparation for the presidential election held on 26 October 2017? And were the candidates who took part in the said election validly nominated? Number 3, what is the place of the Raila Odinga 2013 decision and the Ekuru Au Court judgment in the conduct of the fresh election held on 26 October 2017? On the purpose of a nomination in a presidential election, we looked at Article 137 of the Constitution, Article 138(8), and in summary, we said, at a general level, nomination is depicted as a process through which candidates are identified for participation in an election, subject to them being properly qualified under the law for the elective seat that they seek. It is a critical component of the electoral process without which there would be no election. What about the question whether there was need for nominations prior to the election of 26 October 2017? At paragraph 235, we distilled out the 5 fresh and new elections envisaged under Article 136, 138.5, 139, 146, and 140 sub-Article 3. Having analyzed the issue and looked at the judgments of the 2013 Raila Odinga judgment, we said as follows. In our appraisal of the law relating to the nomination of candidates for presidential election, we prefer this purposive standpoint predicated on the Constitution's intent of assuring unbroken governance process. This leads us to hold that the nominations for presidential election candidates, which took place on 28th and 29th May 2017, remain valid, and no other nomination was required for the election held on October 26, 2017. We affirm, therefore, that all the candidates in that election were validly nominated, and it was proper for the first respondent to include them in the ballot paper as presidential candidates. What of the inclusion of Mr. Jirongo in the ballot? We find no fault in the decision to do so, because the initial decision to include him was based on the fact that the High Court had on 4th October 2017, in Insolvency Course number 3 of 2017, adjudged him to be bankrupt, thus automatically disqualifying him by dint of Article 137, as read Article 99 of the Constitution, from being a presidential candidate. However, although the said decision should have settled the matter, on 16th October 2017, Mr. Jirongo made an application to the High Court seeking a stay of the order which adjudged him bankrupt. By a ruling dated 23rd October 2017, the High Court stayed the bankruptcy order pending the hearing and determination of that application. By virtue of that stay order, Mr. Jirongo became effectively qualified to contest in a presidential election, and therefore, the IEBC decision to include in the ballot through Gazette Notice number 10562 of October 24th was correct. We are unable to understand why the petitioners did not appreciate such a development of definite legal consequence. The third issue is with regard to the Raila Odinga 2013 decision and the Ekuru Aukot 2017 judgment. What standing are these decisions in a fresh presidential election? An issue was raised regarding the application of Raila 2013 in terms of the identification of candidates for a fresh election conducted pursuant to Article 143 of the Constitution. Of relevance in that decision are paragraph 291 and 292, which we have set out verbatim. What is our decision, having analyzed both that decision and the Ekuru Aukot of 2017 decision? We take note of the context in which the judgment in Ekuru Aukot was made and the decision in Raila Odinga. Specifically, the court in Ekuru Aukot directed the IEBC to include the name of Dr. Ekuru Aukot as a candidate for the fresh election. While being in agreement with petitioners that the High Court had directed the inclusion of Dr. Aukot as an additional presidential candidate without mentioning the status of the other candidates, it is clear to us that the court's reasoning at paragraph 73 had contemplated the availability of an opportunity for every other person who had been a candidate in that elections of 8th August 2017 to participate in the fresh election. This is clear from passing that judgment where the judge said, Judge Mativo, the logical construction which to me would serve public interest is that those who participated in the invalid election do qualify in the fresh election. In all the circumstances, we find no fault with the first and second respondents' decision not to conduct fresh nominations. It was a decision fully in keeping with Raila 2013 and later the Ekuru Aukot decision. This position, as correctly argued by counsel for the third petitioner, is binding on them at the time. In conclusion, therefore, it is our finding that the first and second respondents, and indeed the third respondent, as well as all the other presidential election candidates, bear no fault as regards nominations and the inclusion of all the August 8th candidates on the ballot paper. That is the conclusion on issues number 1 and issues number 2. I thank you, Chief Justice.
Thank you, Justice Lenaola. Now I give this chance to Honorable Justice Wanjala to read the judgment on issues number 3 and 4. Justice Wanjala.
Thank you, Chief Justice. The issue number 3, what is the legal effect of the withdrawal of a presidential election candidate before an election? Did any of the candidates validly or properly withdraw from the presidential election held on 26th October 2017? Now, the attribution of illegality to IEBC's retention of the Honorable Raila Odinga's name on the ballot after he wrote a letter withdrawing his candidature was a subject of submissions by all the petitioners. In response, the first and second respondents relied on Regulation 52 of the Elections General Regulations 2012, submitting that save for a withdrawal by a candidate in any election 3 days after nominations, the election laws do not contemplate any withdrawal. And consequently, the Honorable Raila Odinga's letter of withdrawal as a presidential election candidate amounted to just a mere intention to withdraw with no legal effect, as it had not been communicated vide the prescribed form. Now, the question calls for an answer. What is the effect of the alleged withdrawal by the presidential candidate? This entails interpretation of the Constitution and the applicable laws, as well as, again, the effect of the Raila 2013 in that context. We note that neither the Constitution nor the Elections Act makes provision for the withdrawal of a candidate from an election. The procedure for withdrawal of a candidature is instead provided for under Regulation 52 of the Elections General Regulations 2017, and we have cited the provision. It is thus under the law plain that a presidential candidate who intends to withdraw can only do so within 3 days of the nominations by filling the prescribed Form 24A and submitting the same to the returning officer, in this case the first respondent. It was the petitioner's standpoint, however, that Regulation 52 is not applicable to a fresh election because no nominations have been conducted prior to that election. They urged the court to rely on Raila 2013 for guidance on the issue. In that decision, this court held that if a candidate who took part in an original presidential election abandons a fresh election scheduled under Article 140 of the Constitution, the provisions of Article 1388B would become applicable with fresh nominations ensuing. In determining the legal effect of withdrawal by a candidate before an election, what guidance, therefore, can be drawn from the pronouncements of this court in Raila 2013? And the operative paragraphs are 289 to 290, and where the court stated, and we have already cited those statements by the court, by that bench on 2013. These 2 paragraphs have assumed judicial prominence since the nullification of the presidential election of 8th August 2017 by this court. Not only have they been subject to contradictory interpretations by parties to the petitions before us, they have also elicited varying, in quotes, expert comment from many quarters. In the High Court before Mativo J, the question arose as to whether the Supreme Court pronouncements constituted ratio decidendi and were therefore binding on him, or whether they were obiter dicta. The situation is even more complex as the Ekuru Aukot case is now on appeal, pending determination before the Court of Appeal. This is significant in view of this court's general policy of staying its hand in a matter that is pending before another superior court. The relevance of such questions in this instance calls for a consideration of the point whether the above paragraphs in Raila 2013 are of binding authority. The second question is whether this court should, notwithstanding the fact that the matter is pending on appeal, proceed to determine this issue. And the third question is whether it is necessary for the court to make a clarification of the meaning of the said paragraphs in view of the contradictory interpretations attendant upon them. To the first question, it is not in doubt that in making some of the pronouncements it made, the Supreme Court then was responding to hypothetical questions that had been expressed before it by the Attorney General in his capacity as amicus curiae. The questions were not essential for the determination of the two petitions before the court, and the answers to them could not therefore constitute the ratio decidendi of Raila 2013. To that extent, therefore, the pronouncements in those and other related paragraphs were obiter dicta and thus not binding on other courts. Mr. Justice Mativo, in his carefully thought out judgment in Ekuru Court, is not therefore to be faulted for having characterized the said statements as such. As to whether this court should determine this matter while it's pending on appeal, it is apparent to us that this is no ordinary matter, resolution of which can await the appellate process. The petitions now before us could stand or fall on the basis of how we determine the twin issues of withdrawal of candidature and nominations, as the Supreme Court in this instance is exercising its original and exclusive jurisdiction under Article 140 of the Constitution. An abnegation of its task is not tenable, and the responsibility devolves to it to resolve the relevant questions without reservation. The court's task is to determine this presidential election petition. To the third question, in ordinary circumstances, having declared paragraphs 286 to 290 of the Raila 2013 decision obiter dicta, there would be no need to clarify their meaning, since they are of no binding effect. However, though obiter, these pronouncements hold special stature, emanating as they do from the apex court. It is proper, in the circumstances, to consider the content of paragraphs 289 and 290 as the suppositions today have a live face before us. Paragraph 289 therefore reads, "It is clear that a fresh election under Article 143 is triggered by the invalidation of the election of the declared president-elect by the Supreme Court following a successful petition against such election. Since such a fresh election is built on the foundations of the invalidated election, it can, in our view, only involve candidates who participated in the original election. Thus far, it is clear to us that the foregoing statement represents the correct legal position. But the paragraph also reads, in that case, there will be no basis for a fresh nomination of candidates for the resultant electoral contest. The foregoing statement is only correct to the extent that it refers to the nullification of an election of the president-elect where the issue of nomination of candidates was not the basis for the nullification of the election. If the petitions before us, in the petitions before us, the nomination of candidates was not the basis for the nullification of the election of 8th August 2017. But if an election is nullified on the basis of flawed nominations, it is clear that the ensuing fresh election cannot be conducted on the basis of the same flawed nominations. Fresh nominations would, in the circumstances, have to be conducted. Coming to paragraph 290, which appears more conjectural, the paragraph reads, suppose, however, that the candidates or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date, then the provisions of Article 1388B would become applicable with fresh nominations ensuing. It is clear to us, with the benefit of hindsight, that had the foregoing pronouncement not been made obiter, had it been a ratio, it would have been made per incurium, since Article 1388B of the Constitution only contemplates 3 scenarios of a cancellation of an election. And we have set out what these 3 scenarios are. Withdrawal of one candidate from the electoral contest is clearly not one of the scenarios contemplated by Article 1388B as a basis for the cancellation of an election. In the circumstances, this court would have had to depart from that decision, the decision in question. Our immediate question, therefore, is, did the presidential candidate for NASA withdraw from the 26th October 2017 electoral contest? It has been submitted by the respondents that because he did not effect his withdrawal by the prescribed Status Reform 24, the Honorable Raila Odinga's purported in court's withdrawal was of no legal effect. On the other hand, the petitioners urged that the withdrawal was effective as it was notified through a letter, and that Regulation 52 was inapplicable to this particular case. It is clear in the above context that Regulation 52 provides for withdrawal for candidate within 3 days of the nominations. The said regulation is clearly not applicable to the situation at hand. The nominations had long been conducted before the scheduled fresh election. Does this mean that after expiry of the 3-day period, no candidate can withdraw from an election? We don't think so, as one cannot be forced to participate in an election in which he or she has lost interest. The NASA candidate, in our view, not only made a public announcement of his decision to withdraw from the elections, but addressed a formal letter to that effect to the first respondent. Such action, in our perception, constituted a substantive and legally effective withdrawal from the elections. What legal effect, therefore, did the withdrawal of the NASA candidate have on the 26th October elections, if any? It was submitted by the petitioners that the withdrawal should have led to the cancellation of the elections. In our view, in view of our observations in the foregoing paragraphs, it emerges that the withdrawal of the candidate from the 26th October 2017 fresh presidential election could not, in law, have occasioned the cancellation of the elections. That settles issue number 3. Then we move to issue number 4. Was this a free and fair election as required under Article 81 of the Constitution? We are of the view that this issue cannot stand on its own, as it is inextricably intertwined with other issues and questions requiring resolution, and we have set out those questions. It is the second and third petitioner's case that the first and second respondents violated the constitutional right to universal suffrage by failing to provide an opportunity for every person to vote in the presidential election held on 26th October. They urge in that regard that due to violence and intimidation, the first respondent chose not to conduct the election in 27 constituencies, thereby disenfranchising a significant part of the electorate. On its part, the first respondent submitted that it provided the requisite infrastructure in all the polling stations across the country, and every effort was made to train the electoral officials in all the 290 constituencies for the conduct of the 26th October election, save that it was prevented from taking electoral materials to certain polling stations, a matter beyond its control, and so was unable to hold elections in 27 constituencies on the election date. Now, every citizen, of course, has a right to exercise, to vote under Article 38 of the Constitution. The dimensions of this right and the corresponding obligations to effectuate it have been extensively set out locally and in other comparative jurisdictions. And we make reference to Moses Wetangula, Muskari Kombo cases, and other cases from other jurisdictions. It is not left to the state and state organs to guarantee the right to vote. The obligation also binds the voters themselves. And this matter was illuminated in Gatirao Peter Munya versus Kithinji and others in the concurring opinion of the then Chief Justice Willie Mutunga. Now, on the same line of principle, the Inter-American Court on Human Rights has stated that the court's task is to determine whether the alleged violation is the result of a state's failure to fulfill its duty to respect and guarantee those rights. Who then bears responsibility for the denial of the right to vote in the affected areas? And in answering this question, we have made reference to a number of cases. But in a nutshell, it is our finding that neither the state nor the IEBC bears responsibility for failure of voting in certain areas of the country. Such failure could be attributed to unidentified private citizens and political actors who actively caused the offending situations directly or indirectly. The validity of the fresh election, therefore, cannot be successfully challenged on that ground. Now, we have also addressed the question of intimidation, violence, and improper influence. Now, while being alive to the fact that the third respondent has on various occasions expressed his dissatisfaction with the judgment delivered by this court on 1st September 2017, we note, contrary to the second and third petitioner's position, and we are speaking for ourselves in this regard, that no judge of this court was intimidated by the choice of words by the third respondent. In our view, it is not enough to reproduce the third respondent's political statements and attribute an effect upon the judges to those statements. The second and third petitioners also claimed that on October 2nd, 2017, the third respondent met 10,000 women supporters at State House, Nairobi, and officially launched a group known as the Jubilee Women Brigade, adorned in police and military uniforms, and that the group later went on to recruit and administer oaths to new members in areas such as West Pokot, Nakuru, Mombasa, and Nairobi. According to the petitioners, the act of dressing military regalia was meant to, and did in fact, intimidate voters who were not supporting the Jubilee Party. Such allegations, as we find, are made without any proof at all, and we have no choice but to dismiss them. Again, it is not enough to plead such a grave matter without tangible evidence of its bearing upon the electoral process. There was a sub-issue of the use of public resources, which we have extensively also addressed. The second and third petitioners contend that following the nullification of the presidential election results on 8th August 2017, and throughout the campaign period, the third respondent caused to be published by way of advertisement the achievements of the government in the electronic media and in the government delivery portal. And according to the petitioners, the said advertisement was meant to exert improper influence upon voters to support the third respondent's re-election bid contrary to law. We note that the same issue arose during the hearing of Raila 2017, and we observed that the issue of advertising by government during campaign time was then under litigation in the High Court. Consequently, we restrained ourselves from delving into the merits of that issue to allow the High Court to proceed and determine it. And subsequently, on 19th October 2017, the High Court made a determination on the issue in the case of Apollo Mboya versus the AG. And the High Court issued a declaration that the Kenya government delivery portal to advertise its achievements by the national government on various programs undertaken across the country for 4 years was unlawful, as it was made in violation of Section 14(2) of the Election Offences Act. The High Court issued an order of permanent injunction. We note that the High Court gave a clear determination on the issue and forbade the government from advertising using state resources during campaign time. This decision was delivered on 19th October 2017, just a week before the repeat presidential election was held on 26th October, and it specifically related to events and actions prior to the election of the 8th August 2017. The second and third petitioners do not indicate whether the third respondent was in violation of this High Court order prior to the 26th October, or was specifically held liable for any advertisements by the government on 8th August 2017. The petitioners have also not indicated any specific instances where the government, through the print and electronic media, advertised its achievements during the campaign period for the election of 26th October. There is insufficient evidence, therefore, placed before us on whether the third respondent had in any way used government advertisements during the 60 days leading up to the election as a campaign tool, and we have no option but to dismiss the petitioner's claims in that regard. As to whether the second and third petitioners also contended that the fresh election was not conducted by an independent and competent body, and that the record of this petition is replete with evidence that the second respondent and some of its commissioners and its secretariat were not independent of political influence, and neither were they impartial, fair, or neutral. And from that contention, they proceed to make the inference that IEBC was not competent in the to conduct the election, and consequently, the election was rendered a sham. Such, in our view, is a bare contention, which besides implicitly denigrates the very constitutional and legal process which has entrusted the conduct of election to a duly appointed agency, in that case, the IEBC. The contention, in effect, argues against the very concept of legality under the constitutional process. Such a stand is negative and can only invite disapproval by this court, and accordingly we hold the contention in question to be devoid of merit.
Thank you very much, Justice Wanjala. I now give this opportunity to Justice Njoki to read the judgment of the court on issue number 5.
Thank you, CJ. The issue is, what are the legal consequences of not holding a presidential election in each constituency? Apart from the pleadings and submissions before court, we take judicial notice of the fact that there was violence experienced in some parts of the country on 26 October 2017. The violence was more pronounced in the 25 constituencies where it was not possible to conduct an election. These 25 constituencies are considered or perceived to be strongholds of NASA, whose candidates had opted not only to withdraw from the elections, but rallied their supporters to boycott the election. We take judicial notice of the fact that in those constituencies, as well as parts of Nairobi, officials of the second respondent were physically prevented from accessing the polling stations to which they had been assigned for the purposes of conducting the election. In response to our question as to the cause of the said violence, Ms. Julie Soweto, counsel of the second and third petitioners, submitted that it did not matter who caused the violence. In counsel's view, the fact that the violence occurred in certain parts of the country was enough to vitiate the election. It was not, in our view, a meritorious response by learned counsel. Violence in any form, by any person or agency, whether private or state, against any person, community, institution, or establishment constitutes a travesty of justice and of the rule of law. Violence undermines the democratic process and makes a mockery of the pacific resolution of disputes, which is one of the hallmarks of our progressive constitution. Unchecked and unbridled episodes of violence are a sure recipe for the disintegration of a nation and the destruction of a constitutional order. This court stands not for lending legitimacy to any acts of violence as a device for settling disagreements or agreements. Where any state agency, such as the police, who are allowed to resort to a limited measure of force to prevent crime, protect lives and property, and quell violent insurrection, to deploy excessive force resulting in injury, destruction of property or death, they certainly would be undermining the authority of the Constitution. By the same token, where civilians, for whatever reasons, resort to acts of violence and intimidation with the object of preventing others from exercising their democratic right to vote or impeding election officials from executing their constitutional responsibilities, such civilians will engage themselves in the atavistic path of undermining the authority of the Constitution. The Constitution categorically says that every person has an obligation to respect, uphold, and to defend it. The terms of Article 81 of the Constitution, read in proper context, must be understood to mean that no person, candidate, political party, party agent or supporter, or state agency is to resort to acts of violence, intimidation, improper influence or corruption to defeat the will of the people exercising their democratic right. The said provision cannot be read as sanctioning or lending legitimacy to acts of violence and intimidation to achieve the invalidation of an election. If we were to hold otherwise, the authority of the Constitution would be surrendered to cynical acts of violence. All one would need to do is to instigate violence in any corner of the Republic during the presidential election and thereafter petition this court to nullify the election. Those who intentionally instigate and perpetrate violence must not plead the same violence as a ground for nullifying an election. The right to vote is enshrined in Article 38 of the Constitution, and the Elections Act also provides that every adult citizen shall exercise the right to vote. We have already established that the presidential election could not be held in certain constituencies because of the threat of insecurity caused by violent demonstrations. In that regard, the IEBC invoked Section 55B of the Elections Act, postponing the conduct of the repeat election to 28th of October 2017. The IEBC is empowered by the Elections Act to postpone an election in a constituency, county or ward in circumstances specified by the Act. However, there is a non-obstante, which is a nonetheless qualification, proviso to that provision. The Commission may, if satisfied with the results of the elections, if satisfied that the results of the elections will not be affected by voting in the area in respect of which substituted dates have been appointed, direct that a return of the elections be made. And we have spelt out the terms of Section 55B and made this observation. Inherent in the statutory provisions are certain vital points. One, the Commission is a constitutional body under the Constitution to conduct elections. Two, Article 82 of the Constitution empowers Parliament to enact legislation to provide for the conduct of elections. Three, it follows then, Section 55B therefore confers upon the Commission a discretion to consider the circumstances necessitating postponement of an election in an election unit, such as the likelihood of a serious breach of peace. There is a low threshold placed upon the Commission in exercising its discretion to postpone an election. Mere apprehension of the breach of peace may trigger the exercise of this power. In the instant case, it was actual and not imagined threat of violence in the affected areas. Therefore, the Commission's actions were not outside the contemplation of the law. It follows that Section 55B is a normative derivative of the Constitution annexed to Article 82 of the Constitution to aid the conduct of elections in line with the principles of the electoral system and the prerequisites of voting in Articles 81 and 86. Section 55B has a clause allowing the Commission to direct the return if it's satisfied that the outcome will not be affected by the voting in that area. We have listed also the Regulation 87, which also further provides for that. In particular, it states, provided that the chairperson of the Commission may declare a candidate elected as president before all constituencies have delivered their results, if it is in the opinion of the Commission that the results that have not been received will not make a difference with regards to the winner. In the present case, voters from 25 constituencies did not vote due to politically instigated violence. There were also individuals who opted to boycott the election. The IEBC then designated a different day. However, even on this day, elections could not take place. Consequently, upon tallying and verification of results, the Commission declared the winning candidate president, despite the electorate in 25 constituencies not having voted. It is clear that the Commission made its declaration pursuant to the Constitution and pursuant to the law. On that basis, even though those voters in the 25 constituency did not vote, the declaration of the results by the Commission was in perfect accord with the terms of the Constitution.
Thank you very much, Justice Njoki. I now request Justice Ojwang to read the judgment on issue number 6.
One of the grounds upon which petition number 4 of 2017 is anchored is that the fresh election was marred by illegalities and irregularities. The petitioners cite several items under that head: failure to conduct nominations, ungazetted and designated returning and presiding officers, and or illegally appointed returning and presiding officers, ballot papers with candidates whose names should not have appeared, arbitrary relocation of polling stations on election day without notice, failure to conduct a legitimate, credible, and transparent process, and lack of transparency. To support these allegations, the petitioners rely upon the supporting affidavits of Mr. Njonjo Mue and Mr. Billy Atudo, shown on the 5th of November 2017. We have already considered some of the alleged illegalities and irregularities in detail, in particular, the issue of nominations for the fresh presidential election and the appearance of certain candidate names on the ballot paper. Our position on such issues is now quite clear. The petitioners contend that the conduct of election lacked transparency for failing to disclose the total number of voters who had turned out to vote on the 26th of October 2017. To support this, they argue that on the 26th of October 2017, the second respondent had intimated that the final voter turnout would be known by the close of voting at 17 hours, but that the second respondent failed to disclose the total extent of voter turnout on the 26th of October 2017, and that thereafter the proportions kept changing from 48% to 34% and thereafter to 38%. The second and third petitioners contended that a number of returning officers and presiding officers in the election did not turn up on the date of the election, and that the election was presided over by officials who had been illegally appointed, and that any returns prepared by such officials contravened the Constitution. To support this argument, the petitioners invoke the High Court decision, Judicial Review Application number 628 of 2017, Kelef Khalifa and Hassan Abdi against Independent Electoral and Boundaries Commission, wherein the High Court had held that the appointment of returning officers and their deputies was illegal. In response to this argument, all the respondents, together with the interested parties, by contrast, submitted that the appointment of the constituency returning officers and their deputies was quite legal and proper. The attention of this court was drawn to the fact that the issue is a subject of a pending appeal before the Court of Appeal. It was the respondents' further contention that, contrary to the petitioner's allegation, the judgment by Justice Odunga in Judicial Review number 628 of 2017 did not invalidate the appointment of the constituency returning officers or their deputies. At any rate, they submitted that the said judgment of the High Court had been stayed on the 25th of October 2017 by the Court of Appeal. From the submission of the parties, it is clear that this issue was canvassed in Judicial Review Miscellaneous Application number 628 of 2017. And the court held, the court made its holding in quite a number of points which you have recorded and you'll be able to read them. Upon the discovery of the said judgment, upon the delivery of the said judgment, the IEBC filed an application at the Court of Appeal, Civil Appeal number 246 of 2017, seeking a stay of execution of the decision of the High Court, pending the lodging, hearing, and determination of the intended appeal. Upon the hearing of the application, the Court of Appeal made the following ex parte interim orders. The impugned decision of the High Court has a potential of rendering the presidential elections slated for the 26th of October 2017 irregular, even before the elections are held, thus precipitating another election outside the stipulated 60 days and in contravention of the provisions of Article 143. For the avoidance of doubt, this order means that the constitutional and statutory functions of the returning officers and their deputies relating to the presidential elections slated for the 26th of October 2017 are not invalid. End of quote. In the above context, the petitioner's claim rests squarely upon a single case, Khelef Khalifa, which is now the subject of a pending appeal. By the High Court's decision, the said appointment of returning officers and their deputies had been tainted with illegality, and so all such returns as emanated from such officials were in contravention of the Constitution, and consequently, the election result in question should be annulled by the petitioner's cause. Such a contention is contested by both the respondents and the interested parties. They maintain that the appointment of the constituency returning officers and their deputies was in due compliance with the law in every respect. They urge further that the issue is sub judice, as it is the subject of future determination by the Court of Appeal, which has already ordered in the Khelef Khalifa case that the matter rests in abeyance and is to occasion no prejudice for the moment in relation to the exercise of the mandate of the said electoral officials. The respondents, in advancing their standpoint, have observed that Mr. Justice Odunga in the Khelef Khalifa case had not taken any action to invalidate the appointment of the said polling officials. Whereas the respondent's position represents a valid status quo and the legal status of the returning officers thus cannot be denied, this court has an obligation to set the matter to rest. The court is considering an electoral matter in which it takes the first instance and the ultimate instance. Its singular jurisdiction in the electoral matter is to be secured by holding that the current legal status of the said electoral officials carries validity for now and for the future, irrespective of such determination as may later be made by any other court on the matter. Guided by exigency and by judicial notice, which must be taken of the reality of discharge of the assigned mandate of the electoral agency, we now hold that the officers in question lawfully held their positions and duly discharged the constitutional mandate devolving to them. This is also because on the election date, the stay orders granted by the Court of Appeal were firmly in place, and to state otherwise would be to negate the value of the validity of court decisions unless and until they are overturned. The decision of the High Court, to that extent, cannot be the basis for invalidating the 26th October election. Accordingly, we find no validity in the petitioner's claim that the said returning officers and their deputies lacked authority. The second and third petitioners submitted that on the 26th of October 2017, without notice or further direction to the voters, the first respondent arbitrarily relocated the following polling stations: Kibra, Sarangombe Ward, K-Age Olympic Education Center, and Kibra Sarangombe, Kibra PAG Church School. Those are the ones. The petitioners contended that the second respondent dishonestly claimed that an election had taken place in areas such as St. Mary's polling station within Mombasa County, when the voters did not have a real opportunity to vote, and that this showed dishonesty, especially by representing that an election took place when the majority of voters were disenfranchised. They urged that there was no fair election. In response, the first and second respondents stated that by moving the polling station, they acted within the powers provided for under Regulation 64(2) of the Elections General Regulation 2012, which allows presiding officers to transfer polling stations to another polling station or public facility. In addition, it was their submission that the notices of transfer were displayed conspicuously at the polling stations, and anybody who visited the polling station would have seen them. It was their submission that the move was necessitated by the fact that the polling station had been barricaded and replaced with bonfires, and this, coupled with escalating violence, made it impossible to vote at these stations. Thus, the returning officer for Kibra advised the presiding officer to move to Olympic Primary School, which was secure, and they placed notices at the entrance to the center, informing voters of the new stations. This was corroborated by the third respondent, who emphasized that the first respondent's official acted within the law and that the transfer was necessitated by violence that had erupted in Kibra constituency. With regard to Changamwe, the first and second respondents relied upon the affidavit of the returning officer for Changamwe, Ms. Luciana Jumwa Sanzwa, dated the 12th of November 2017, who averred that no polling station was set up in any ungazetted area, as there was no occurrence of events such as warranted such an action, and voting went on normally. We note that the allegations as regards Kibra constituency have not been substantiated with any evidence showing that only 2 people voted at the polling station. No one has come up to say that he or she would not trace or find the polling station after it was moved. It is also admitted that the polling stations were moved as a result of violence that erupted, and that the first respondent exercised the powers which are conferred on it under Regulation 64(2) of the Elections General Regulations 2012. In this regard, the allegations by the petitioners are in generality and are not supported by any evidence, and they have been rebutted by the various returning officers. The second and third petitioners submitted that at least 28% of the people who turned out to vote in the fresh election could not be identified biometrically, contrary to representations made by the second respondent that they would put in place a biometric register that is secure and accurate. This, they submitted, raises doubt concerning the actual number of people who turned out to vote in the fresh election. It was submitted that the people who were identified by the KIEMS kit were only 5.5 million voters, and that there were about 78,000 voters who were not identified but still voted. The petitioners contended that there were discrepancies between voter turnout as recorded in Forms 34A and as captured and recorded in the OT-MOFO KIEMS kits records and logs in a sample of about 100 polling stations in Garissa and Murang'a. It was contended that in some polling stations, the turnout gap between the Form 34A and in the KIEMS kit is more than half of the total number of registered voters in that station. On behalf of the first respondent, it was submitted that for the authenticity of the transmission logs from the KIEMS kits that were provided to court, the affidavit of Silas Njeru provided the requisite explanation. It was submitted that the KIEMS kits have different resolutions, and it all depends on how the returning officer sets it as regards the pictures produced. The KIEMS kit is a standalone gadget, and no image can be transmitted in the system unless it originates from the KIEMS kit. On the failure to transmit both the text results and the image of the Form 34A, it was submitted by Mr. Mahat, counsel for the first respondent, that first there was no evidence that anyone was prejudiced by the omission to transmit the text results. Secondly, upon the High Court order to include Mr. Aukot and other candidates, the company reconfiguring the KIEMS kit was categorical that having already reconfigured the kits with 2 candidates, it would need more time to incorporate all the candidates. However, this was not possible since the Supreme Court order for a fresh election under Article 140, Sub-Article 3 of the Constitution was time-bound. He urged that where there is a conflict between regulation and the Constitution, it must be the Constitution that takes precedence. The third respondent went through the process of KIEMS kits identification through biometrics and the complementary manual identification to the alphanumeric setting and document search using the surname or other names. This was corroborated by the first interested party who confirmed to court that the complementary identification system was working. The third respondent urged the court to find that the second respondent acted in a transparent manner by opening up his servers without being prompted immediately after the first respondent declared the third respondent as the president-elect on the 30th day of October 2017 to enable candidates and observers to have access to information in his servers. The second and third petitioners contend that through Kura Yangu Sauti Yangu, they received and analyzed about 1167 forms 34A from its observers. Out of the total of 1,167 forms, 55 were not signed by agents, while 1,112 had agents. Out of this number, 1,106 forms were signed by the Jubilee Party agents only. Out of the 266 forms, 34B obtained and analyzed by KYSY from the second respondents portal, 250 were signed only by Jubilee Party agents and only 12 were signed by Jubilee agents as well as other party agents. Now, following this, the petitioner submitted that despite the Supreme Court's decision that the Forms 34A, B, and C needed to be standardized, verifiable, accurate, and authentic, there is evidence, as outlined above, that some of the forms transmitted by the second respondents are either forgeries, had mathematical errors, or were altered. In response, the third respondent, on his part, submitted that the first respondent conducted elections that are free, fair, secure, and transparent, devoid of discrimination, with the full participation of the public and other stakeholders, and in a manner that is simple, verifiable, and accountable. The difficulty with the second and third petitioner submission on this issue is that, not being candidates or agents, they may not really be privy to the nitty-gritty of the operations of the electoral process. It is undisputed that the second respondent developed a compliance and a legal matrix to guide it in the transmission process. The petitioners, however, make general allegations, but without specifying in what manner transparency was not achieved and in what aspect. It is worth noting that most polling stations had agents mainly from the third respondent's party. However, save for the bare allegations made by the petitioners, we were unable to detect such serious anomalies as to demand that the election should be invalidated. The second and third petitioners urge that the second respondent did not put in place a biometric voter register that was secure and accurate, making it prone to electoral fraud. They submitted that, according to the evidence on record, at least 28% of the people who turned out to vote in the fresh election could not be identified biometrically, raising doubt as to the actual number of people who voted. It was urged that failure to use the electronic system of voter identification to identify voters was meant to misrepresent the voter turnout. In addition, that there were unexplained changes in the total number of registered voters between the 30th of June 2017 and 26th of October 2017. It was submitted that in an audit conducted by KPMG on the voters register, only about 5,000 voters were classified as having been registered without biometric records. Yet, the first respondent claimed that there were about 1.6 million voters identified without biometrics. In the second and third petitioners' view, this was indicative of electoral fraud and breached their legitimate expectation that the ICT systems would work with a seamless complementary mechanism in cases where the KIMS-KIT experienced systems failure. They referred to the Court of Appeals decision in NASA against Independent Electoral Boundaries Commission, Civil Appeal number 258 of 2017. It is our perception that the issue of a voters register, when raised in any election proceedings, is a primary issue for determination. Registration of voters is also a constitutional imperative. By Article 83 of the Constitution, which outlines the prerequisites of voter registration, certain specific provisions are made. When a person qualifies for registration as a voter at elections or referenda, if the person is an adult, is not declared to be of unsound mind, has not been convicted of an election offense, a citizen who qualifies for registration as a voter shall be registered. And that registration facilitates the effectuation of the right to vote. Article 38(3)(a) decrees that every adult citizen has a right, without unreasonable restrictions, to be registered as a voter. As such, the right to vote cannot be fully enjoyed if the registration of voters is not properly conducted. The second and third petitioners thus contend the voters register was not simple, not accurate, not verifiable. There were more than one voters register between the general election held on the 8th of August 2017 and the fresh election of the 26th of October 2017, and the KPMG audit report noted numerous anomalies in the register and that the register facilitated multiple voting. These concerns have been rebutted in the responses by the first, second, and third respondents in their various depositions. Certain factual concessions were, however, made. The allegation that the register kept mutating was withdrawn in the last paragraph of Mr. Billy Atudo's affidavit, as noted by counsel for the third respondent, Mr. Tom Macharia. It was further noted that the varying figures were as a result of the inclusion of prisoners in the county totals. A pertinent issue of factual verification, however, is whether the total numbers of registered voters declared by the first respondent in Forms 334C during the 8th of August and 26th of October elections and those published in the Gazette in terms of Section 14 of the Elections Act and Regulation 12.4 of the General Registration of Voters Regulations 2012 tallied. Exhibit WC2 annexed to the affidavit of Ms. Winnie Gushu is a Gazette notice number 6250 dated the 27th of June 2017, certifying that the revision of the register of voters had been completed for purposes of the general election held on the 8th of August 2017. The total number of registered voters in all the counties, according to this Gazette notice, totaled 19,601,502. In addition to this number, a total of 5,528 persons were registered in the prisons, and a total of 4,393 registered in the diaspora, making a grand total of 19,611,423. Exhibit WC3, Gazette Notice number 8751, annexing the affidavit of Ms. Gushu, suspended the registration of voters and revision of the voters' roll until the 8th of November 2017. The import of this suspension is that the total number of registered voters contained in the register used for the 8th August general election was still in operation during the 26th of October 2017 fresh presidential election. Did the numbers match? Evidence was pointed to the Form 34C generated during the 8th of August general election and the fresh presidential election. According to the evidence provided by the first respondent, the total number of registered voters, according to Form 34C, was 19,611,423 registered voters, which tallies with the numbers recorded in the Gazette Notice number 6250. The second and third petitioners did not lead further evidence to prove the alleged changes in the number of registered voters, or that indeed this affected the outcome of the fresh presidential election. In any event, the existence of these differences is attributed to the inclusion of prisoners from the total numbers by Kura Yangu Sauti Yangu. The evidence adduced by the respondents, therefore, sufficiently discharges the petitioner's allegations of an inconsistent voters' register. On the issue of the KPMG audit report, it was alleged that the first respondent did not comply with the recommendations of the KPMG audit to, among other things, deal with the presence of dead voters in the register. So what was the genesis of this audit? Part 2 of the Elections Act comprehensively covers the subject registration of voters and determination of questions concerning registration. Section 8A, subsection 3 of the Elections Act places a mandatory obligation upon the Commission to engage a reputable firm to conduct an audit of the register of voters for purposes of verifying the accuracy of the register and updating the register. We have cited the relevant sections. From the materials on record, we noted that in April 2017, the second respondent formally engaged KPMG to conduct an audit on the voters register with the following objectives. 1, to verify the accuracy of the register. 2, to recommend mechanisms for enhancing accuracy of the register and updating the register. According to a press release issued on the 9th of June 2017, the IEBC, after completion of the exercise, the scope of the audit was to 1, review the legal framework relating to voter registration. 2, review the voter registration process, voter transfer process, and voter update process. 3, review the biometric voter registration system and data that hosts the register of voters. 4, review the process of identifying and removing deceased voters from the register of voters. 5, assess the accuracy of the register of voters in terms of completeness of the details of voters, voters' data, and matching of voters' details to the voter. 6, assess inclusiveness of the register of voters in relation to eligible voting population based on gender, age, and geographic distribution. 7, review and recommend improvements on existing mechanism for continuous update of the register of voters. 8, analyze the security of the registration of voters' data and infrastructure it sits upon. And 9, make recommendations for enhancing the accuracy and inclusiveness of the register of voters. The second respondent, in addition, has submitted a copy of the audit report to Parliament in line with the law. The recommendations in the report covered 8 broad areas as follows. 1, stakeholder engagement and feedback. 2, legal and institutional issues. 3, inaccuracies in the register of voters. 4, irregularities in the register of voters. 5, deceased persons in the register of voters. 6, inclusiveness in the register of voters. 7, database security and infrastructure controls. And 8, action plan for the implementation of recommendations. The second respondent further issued a commitment to continue with the stakeholder engagement to promote transparency in the register of voters. The report also noted that in order to address emerging data issues, it was imperative for the second respondent to assert its independence, as well as cooperate with other reinforcing external agencies, such as those concerned with immigration and registrations of births and deaths. This, the report noted, was outside the internal ambits of the first respondent and included institutional coordination and collaboration. The report also noted that at least 5,427 records lacked biometric fingerprint images in the register. A total of 2,900,089 records had a number of inconsistencies, such as mismatched gender and date of birth, mismatched date of birth, inconsistencies in gender, names, and particulars. IEBC noted furthermore that where the details in the register were confirmed to be invalid, they would be expunged from the register. The second respondent in that regard indicated that it would reconcile audit findings and address gaps within 5 days of the press statement, which process had commenced during the verification, and that other issues would be addressed through the new infrastructure and database security software which had been acquired. The second respondent has also pointed out that the register used by KPMG for the audit was provisional in nature. Consequently, it thereafter undertook a verification exercise which cleaned up the register, including removing names of dead voters. Although allegations of voters' register permutations and inaccuracies were raised, particularly with respect to the aspects addressed in the audit report, clear, specific, and direct allegations regarding the voters' register and its effect on the conduct of the fresh presidential election were not made. Indeed, the respondents rebutted these allegations systematically, and while the audit report was a statutory requirement by Parliament to improve transparency and enhance the accuracy of the register, the implementation of the recommendations by KPMG required actions on the part of IEBC, as well as cross-institutional collaboration to facilitate implementation. The more essential concern for the purposes of these proceedings is whether the allegations made in the petition concerning the voters' register affected the outcome of the fresh presidential election. The voters' roll is the centerpiece of an electoral process. At the heart of the right to vote is the obligation of the state to ensure that the registration of voters is undertaken and discharged properly. The Constitution addresses voter registration in 4 separate articles: Article 38, 82, 83, 84. Kenya's history of elections features voter registration as one of the aspects that required intensive reform. When this court determined the Raila 2013 case, the conclusion was that the register was a product of several components. To consolidate these components into one central location, the KIMS was introduced, which is a one-stop gadget with 3 functionalities, these being voter registration, voter identification, result transmission. Each of these components is independent, yet they all reinforce the electoral process. Voter identification addresses some of the fundamental issues that arose in earlier elections. According to the second respondent, it is an elaborate system of identification structured in a way that does not negate any person's right to vote. The composite of the voter identification designs are biometric identification, alphanumeric search with reference to identification documents, alphanumeric search with reference to physical keying in of biographic data, presiding officer authentication, and complementary identification. With the checks guaranteed by these elaborate modes of identification, most of which were witnessed by voters and visible in the logs provided by the second respondent, the second and third petitioners have not met the dictates of proof to show that 1. Dead persons participated in the election. 2. That unqualified persons voted. And 3. That persons with special needs were denied the chance to vote, or that the total number of registered voters was in doubt at the time of the election. We further note that Section 2 of the Elections Act 2011 defines a register of voters to mean a current register of voters of persons entitled to vote at an election prepared in accordance with Section 3 and includes a register that is compiled electronically. As such, a printout of the electronic register for purposes of the election was not in violation of the law. Indeed, as submitted by counsel for the third respondent, Mr. Tom Macharia, Regulation 61, Subregulation 4 of the Elections General Regulations 2012 requires, quote, the returning officer to provide each polling station with both electronic and hard copy of the register of voters, or such part thereof as contains the biometric data and alphanumeric details of the voters entitled to vote at a polling station, end of quote. In conclusion, the voters' roll is subject to periodic inspection as decreed by Section 6 of the Elections Act 2011. The discretion to determine when a register is closed to inspection rests with the Commission. This is necessitated by the administrative needs that attach to electoral management and preparation. This continuous exercise, therefore, shows that the Commission was not under immediate obligation to act on the recommendations of KPMG. The voters' roll is a living document with the addition of eligible persons entitled to vote and the exit of others. Its character also changes, necessitating regular updating. In this regard, Section 8 of the Elections Act 2011 is clear. It says, the Commission shall maintain an updated register of voters. The full quotation is there and you'll be able to read it. The Supreme Court of India reaffirmed the living nature of the voters' roll in the case of Lakamshi Charan Sen, a case that we have cited there, and they said, quote, it is true as submitted on behalf of the Election Commission. A perfect electoral roll is not possible, but at the same time, it must be remembered that the name of any eligible voter should not be omitted from, nor the name of any disqualified person included in the electoral roll in violation of any constitutional or statutory provisions. The error, when pointed out, has to be removed, end of quote. Now, there are processes outlined by the law relating to registration, verification, inspection, audit, transfer of registration, and updating of the voters' register are all time-bound. In this case, the petitioners question processes that occurred before the conduct of the general election on the 8th of August 2017. As was rightly pointed out, the question of the register was addressed by the court in the case Raila 2017, and we have been satisfied that the first respondent did not alter the register as alleged by the second and third petitioners. All evidence adduced and analyzed leads to a contrary position. As such, the answer to the question, what was the effect of alleged neglect by the first respondents to address issues raised in the KPMG audit, must lie in a finding of no effect. In view of all the evidence presented and the submissions, the first and second petitioners' grounds on the voters' register must fail. This court has already pronounced itself in unequivocal terms on the effect of irregularities upon an election. The legal position remains as stated in the majority decision of the court in Raila 2017. Our view is informed by the conclusion which we have made as to the applicable law in relation to the 26th of October 2017 election. This may be restated. Not every irregularity or procedural infraction is enough to invalidate an election. The irregularities must be of such a profound nature as to affect the actual result or the integrity of an election for a court of law to nullify the same. We have painstakingly considered the petitioner's case as stated in the petition and accompanying affidavits. We have, in equal measure, considered the respondents' replies and the accompanying affidavits. We have read and listened with undivided attention to the submissions of all counsel regarding the issue of illegalities and irregularities. We have taken note of the fact that while the petition makes far-reaching allegations of irregularities, the same have been effectively rebutted or explained away in replying affidavits and submissions of counsel. Our examination of sample materials submitted to the court by the first and second respondents, that is forms 34A, 34B, 34C, as against the ones attached to the petitioner's pleadings, lends credence to the explanations given to the court by the respondents. It was not lost on us that while the second and third petitioners made serious allegations of widespread malpractices having characterized the election, various counsel for the petitioners spent most of their allocated time addressing us on collateral issues instead of laying evidence and discharging the burden of proof by addressing the respondents' written submissions. This finding leads us to the unavoidable conclusion that the petitioners have not discharged the burden of proof to the standard established by this court. At no time, in our view, did the burden shift to the respondents. By the same token, the court has not been persuaded that the respondents violated the applicable electoral law in the management of the 26th of October 2017 election. That's it, CJ.
Thank you. Thank you very much, Justice Ojwang. And now give this opportunity to the Deputy Chief Justice to read the judgment on issue number 7.
Thank you, my Lord Chief Justice. What is the effect of the Election Laws Amendment Act 2017 on the conduct of the presidential election held on the 26th of October 2017? And 2, is Section 83 of the Elections Act as amended unconstitutional? The second and third petitioners plead in paragraph 74 and 75 of their petition inter alia that the Election Laws Amendment Bill 2017 was intended to diminish the role of technology in elections, open election results to manipulation, and signal to voters that it would not be possible to successfully challenge the results of the fresh presidential election, even if the same were to be unconstitutional, unlawful, or irregular. They state that the said bill has since become law with the overt approval of the third respondent and has been gazetted as Election Laws Amendment Act number 34 of 2017. Consequent upon that pleading, the petitioners raise for determination by this court at paragraph 140 of their petition the issue that in light of the amendment of Section 83 of the Election Act by the Election Laws Amendment Act 2017, after the conduct of the fresh election, the question would be, which law is applicable for purposes of determining the present dispute, and 2, whether Section 83 of the Elections Act as amended is unconstitutional and invalid. The petitioners then seek various reliefs, the one relevant to the above pleading being that a declaration be made that Section 83 of the Elections Act as amended is unconstitutional and invalid to the extent of its inconsistency with the Constitution. As regards the issue of the applicable law in respect of the 26th of October 2017 election, Our view is that as at the time the cause of action arose, to wit, the 26th of October 2017, the law then applying was the Elections Act 2011. The amendment laws did not become effective until the 2nd November 2017. In that context, therefore, the common practice is that legislation should be effected prospectively and not retrospectively. That is to say, laws should be forward-looking and should not apply backwards in time. Prospective application of legislation is based on ancient Roman and English law, and we've given you a quotation there. We've also quoted some American case where the court said, as I quote, "The principle that the legal effect of conduct should ordinarily be assessed under the law that existed when the conduct took place has timeless and universal human appeal." It is a conventional rule of construction that legislation must be addressed to the future, and a statute should not be given retrospective operation interfering with antecedent rights. We are inclined to the standpoint that legislation should bear only prospective effect in the absence of special legislation signal to the contrary. Where a legislative body thus wishes to change the law regarding a past event or action, its intent is to be clear enough. By this principle, where legislation is ambiguous or silent as to its effective date, it should be presumed to be prospective. In the present instance, when Parliament passed the amendment to Section 83, it did not state that the law shall apply retroactively. The United States Supreme Court in Landgraf made this presumption to statutes altering substantive rights. That court presumed prospectivity to avoid construing a new law that otherwise might have attached new legal consequences to events already completed before the law enacted. Although the Landgraf case dealt with private actions, the reasoning is, in our view, germane to the instant matter. This court has furthermore already pronounced itself on the retrospectivity of laws in the case of Samuel Kamau Macharia and KCB at paragraph 61, which we have reproduced. The issue in this petition, however, is that the amended law was not made retroactive by Parliament and should therefore be read prospectively. It is noteworthy that in addressing the same issue in Moses Masika Wetangula and Muskari Kombo, the Court of Appeal adopted the dicta in Morgan and Simpson and took the position that an election must be guided by the law as it was on the date of the election. And we have reproduced what the Court of Appeal said. From the foregoing, we find that the applicable election law in respect of the conduct of the 26th of October 2017 election was the Elections Act 2011. The Election Laws Amendment Act 2017, Act 34 of 2017, not having come into effect as at the time of that election, and the same not having had retrospective application. The second issue is this. The second and third petitioners seek a declaration that Section 83 of the amended law is unconstitutional and invalid. Having taken into account all the submissions on the matter and being aware as we are that the amended law is the subject of various pending causes before the High Court, such as in the petition number 548 of 2017, the Katiba Institute Africa Center for Open Governance and the Attorney General. We restate our stand in similar circumstances as we did in the matter of the Interim Independent Electoral Commission, where we stated at paragraph 47 of that judgment, and we have reproduced paragraph 47. However, the above position can be distinguished, as we have stated elsewhere in this judgment, from a matter arising in the course of a presidential election in regard to which the Supreme Court has unqualified jurisdiction and where the issue essentially relates to a petition before the court. The Supreme Court, in its advisory opinion in the gender representation matter, advisory opinion number 2 of 2012, stated that its jurisdiction to adjudicate on any dispute touching on the presidential petitions, while acknowledging the mandate of the High Court on determining the constitutionality of a statute, at paragraph 76 of advisory opinion number 2 of 2012, which again we have reproduced overlay. The overlapping jurisdiction between the High Court and the Supreme Court only arises where interpreting or applying the provision insofar as it relates to the presidential petition. Where, however, the challenge to a statutory provision is directed as a ground in the context of a presidential petition, the Supreme Court should not find any difficulty in addressing the same in the context of a presidential petition. This does not include the power to this does not exclude the power to refer the matter to the High Court for its proper disposal depending on the circumstances of each case. We find no reason, therefore, to disturb our already settled principle of not taking away the jurisdiction of other superior courts and determining issues pending thereat. We thus would restate our position in Raila 2017 at paragraph 313, where we stated as follows: having that in mind and fortified by our observation that the interpretation of Section 14 of the Election Offences Act is a live matter at the High Court, we are unable to address our minds to any allegation that touches on this section. That is the end of the matter. Similarly, we leave the issue of the unconstitutionality or otherwise, or invalidity of Section 83 of the amended law to the determination of the High Court, where the matter is currently under consideration. In stating so, we see no prospects of the High Court making a finding that would affect our determination of the present presidential election petition. Thank you, Chief Justice.
Thank you, DCJ. We have in this matter a concurring opinion by our sister, Justice Njoki. I would like to call upon her now to read her concurring opinion. Justice Njoki.
Thank you, CJ. My concurring opinion is on the single issue on the applicability and constitutionality of Section 83 of the Elections Act as amended. Although the parties referred to numerous decisions of this court on matters deserving the exercise of the court's jurisdiction, none linked their arguments to the role of this court on questions touching on the interpretation and application of the Constitution from the perspective of this court's exercise of exclusive original jurisdiction. More specifically, whether an issue touching on the constitutionality of any law integral to the determination of a cause before us, although pending before another court, falls to this court's determination. Section 83 of the Elections Act 2011 was an integral part of this court's consideration of the validity of the 8th August 2017 presidential election. The decision of the majority turned on the disjunctive interpretation and application of this section to the conduct of the election. At paragraph 171, the court, in majority, noted that Section 83 was indeed the fulcrum of the petition. Paragraph 187 of the majority opinion set the stage for the interpretation of this section, and at paragraph 211, the court laid out the application of Section 83 by the courts as follows. Quote, "In our respectful view, the two limbs of Section 83 of the Elections Act should be applied disjunctively. In the circumstances, a petitioner who is able to satisfactorily prove either of the limbs of the section can void an election. In other words, a petitioner who is able to prove the conduct of the election in question substantially violated the principles laid down in our Constitution, as well as other written law on elections, will, on that ground alone, void the election. He will also be able to void an election if he is able to prove that although the election was conducted substantially in accordance with the principles laid down in our Constitution, as in other laws on elections, it was fraught with irregularities or illegalities that affected the result of the election." While the cases cited by counsel in this case revolved around this court's appellate mandate, the Supreme Court's jurisdiction as an election court and the interplay of the Constitution and the law to the issues at hand can be summarized from the reasoning in the Supreme Court, this court's case of Aramat and Lempaka and others, in which, at paragraph 102, we said, the Supreme Court's jurisdiction in relation to electoral disputes is, in our opinion, broader than that of other superior courts. We note in this regard, while the Court of Appeal's jurisdiction is based on Section 85A, that of the Supreme Court is broader from Article 163 of the Constitution. This interpretation and the language of the Elections Act and the Election Laws Amendment Act places Section 83 at the center of any determination by an election court. After the hearing and analysis of the case from submissions and evaluation of the evidence, the application of Section 83 serves as the judge's determinate fact vector. Therefore, although the parties seem to be in agreement that the constitutionality of that section was removed from this court's exclusive original jurisdiction and was the preserve of the High Court on the basis of pending suit, my opinion is that this court's determination of that issue is necessary to complete the mandate bestowed to us under Article 163. As rightly urged, this court has time and again held that issues pending before another court will not be subject to determination before the Supreme Court, but rather this court shall allow the other court to have the jurisdiction to determine the court in the first instance. However, in all those instances, this court had in mind ordinary causes coming before it by dint of Articles 163(4) A or B, that is, appeals from the Court of Appeal and issues of interpretation or application, which must have formed an integral part of the issues raised in the superior courts and been a matter determined by them. It follows, therefore, that this court will exercise deference to another superior court below it in its hierarchy in instances in which the jurisdiction in respect of the matter before it is that superior court. The question, however, is whether the Supreme Court, in hearing a matter in which it has original jurisdiction, will determine an issue of interpretation or application of the Constitution, or whether it will defer the issue to the courts below it. My opinion is that where the court is exercising original jurisdiction, it's imperative for the court to answer in the first instance such questions. Since the determination of a petition challenging the declaration of a presidential election falls to this court, the application of leaving main issues unresolved is the creation of a lacuna in the application of the law. Losing the chance to clarify it until such time until the jurisdiction of the Supreme Court will be invoked in another like matter, or such time as the legislature eliminates the penumbrous occasion therein. The grave occasion of this court's acceptance of the submissions of counsel to skip the central determination revolving around the constitutionality of Section 83 as amended leaves a matter properly before this court unresolved. The Constitution does not countenance a situation whereby this court makes a partial determination on any matter, especially in an election cause. This court is enjoined to determine with finality matters before it, and the resolution of the presidential petition under Article 1 is one of them. Failure by this court to determine that issue will leave part of the dispute between the parties unresolved. In terms of Section 83, it would have the effect of leaving undetermined the fulcrum of the election cause itself. Consequently, the resultant decision would be one falling short of the explicit commands of Article 140 and Article 159 that justice shall not be delayed and the purposes and principles of the Constitution shall be protected and promoted. Such an incomplete decision would also be contrary to the distinct objects of the court which are set out in the Supreme Court Act. In context, the petitioners invited the court to determine the following issues inter alia. Quote, in light of the amendment of Section 83 of the Elections Act by the Election Laws Amendment Act 2017, after the conduct of the fresh election, which law is applicable for purposes of determining the present dispute, and whether Section 83 of the Elections Act as amended is unconstitutional and invalid. In consequence, the petitioners sought a declaration that Section 83 of the Elections Act as amended is unconstitutional and invalid to the inconsistency with the Constitution of Kenya. In response, the first and third respondent urged that Section 83 of the Elections Act 2011 was amended after the election, the subject of the petition herein having been conducted. Consequently, they argued that Section 83 is not law that is applicable to the determination of the election petition herein. As elaborated earlier, the issue of the constitutionality of Section 83 is integral to the determination of the present petition. As preferred earlier, this court is enjoined to resolve disputes between parties with finality. Therefore, in order for this court to determine with finality the question of validity of the declaration of the president-elect, it must inevitably determine all issues. This court is charged to signal the law it has arrived on in arriving at its determination in any matter, more importantly, in determining the validity of a declaration in a presidential election, and for good reason. Firstly, it attracts enormous public interest. Secondly, other courts look to this court to offer a guiding compass on interpretation and application of the Constitution and its interplay with applicable laws. And thirdly, for certainty and predictability of Kenya's electoral jurisprudence. I emphasized on the right-centric nature of election petitions and the pivotal nature of precedent-setting decisions of this court in Raila Odinga 2017, where I did say, quote, it is proper to emphasize that the Supreme Court, in discharging its mandate as an election court, remains a setting forum in the country, and its decisions must be carefully analyzed to ensure that a jurisprudential crisis or confusion does not ensue. Were that to happen, the court would have failed the Constitution and the people, end quote. I agree with the submissions made by Mr. Ogeto for the third respondent to the extent that the doctrine of presumption of constitutionality would be applicable in respect to Section 83, as long as the provision has not been adjudged unconstitutional by any court. However, there is pressing need for this court to conclusively the present petition together with all issues, and therefore the two key issues, that is, whether Section 83 of the Elections Act is the applicable law and whether it is inconsistent with the Constitution, must be addressed. I will address the two. Whether Section 83 is the applicable law. The Elections Amendment Act 2017 was passed by Parliament on the 12th of October 2017 submitted to the President for assent on the 13th of October. The Constitution provides that the President must assent to the bill or return it to Parliament within 14 days. If he does not, the bill is deemed to have been assented to at the end of the period. The President did not assent to the bill, and by operation, it was deemed assented on the 27th of October. It was then published in the Kenya Gazette on the 2nd of November. Since the Act provides that the law comes into force on publication in the Gazette, it came into force on the 2nd of November. It was the submission of counsel for the petitioners, the first and second respondents, the Honorable Attorney General, and counsel for the first interested party that the amendment law was inapplicable to the present petition. However, counsels did not consider the import of Section 83 in isolation from sections of the Election Laws Amendment Act, or to distinguish its application from those sections. Section 83 of the Elections Act appears in Part 7 of the Elections Act under the heading Election Petitions. More specifically, it addresses the court after an election petition has been filed before it. In this instance, the determining cause triggering the application of the law is the cause presented for the court's determination. Section 83 contains the test to be applied by a court while determining an electoral cause before it. Therefore, it is an electoral event, like the election. It follows the declaration by a judicial officer on an election cause. In my interpretation, Section 83 as amended is therefore the applicable law, not just in this petition, but in other election petitions and appeals to other courts. The second question is whether Section 83 as amended is unconstitutional or invalid. The petitioners imputed the constitutionality of the amended Section 83 of the Elections Act, Articles 81 and 86. Their argument is that its disjunctive application would violate the principles of the two provisions. In addition, they generalized their claim of unconstitutionality to 4 constitutional imperatives. 1, the independence of the judiciary. 2, the right to public participation. 3, the right to universal suffrage. And 4, the constitutionality and other statutory duties of the Commission. The challenge therefore goes to, quote, the legislative intent in enacting the legislation and the textual violation of certain rights and obligations under the Constitution and principles of the electoral system. These aspects provide sufficient grounds because the issue of unconstitutionality was pleaded and canvassed to sustain a claim for determination before this court. Any challenge of constitutionality or otherwise, or on the basis of inconsistency with the Constitution as directed by Article 2.4 of the Constitution. The role of a judge is to compare the impugned law or action with the provisions of the Constitution to determine consistency or otherwise with the Constitution. There must be an implied or incomplete argument touching on the constitutionality to exhaustively determine a claim of inconsistency with the Constitution. Inconsistency on the basis of statute and on the basis of conduct are distinguishable and ought to be comprehensively pleaded. The petitioners challenged the amendment laws on the basis of invalidity of the law and legislative conduct of Parliament. The argument was that the purpose and effect of the law was at variance with Article 81 and 86 of the Constitution, and that the conduct of Parliament in enacting amendment laws stifled or overlooked the voices of critical Kenya, compromising national consensus. I must say at this stage that it is not enough to plead inconsistency of a law with the Constitution as a tangential issue in a case. Claims of inconsistency must be well pleaded, and where the court determines that such a critical question was given peripheral treatment, it may exercise its discretionary powers to ask the parties to delve deeper. The consideration of any law or the conduct against the Constitution is central to any legal proceedings. In the present case, the general position of the party, faulty in my opinion, was that the issue of constitutionality of Section 83 as amended was removed from this court's jurisdiction due to a pending suit before the High Court. A perusal of the matter pending before the High Court revealed a claim made in respect to 3, in which that petition says Section 9 of the Elections Law Act is unconstitutional because it creates a statutory threshold of invalidation of an election that is more onerous than what is contemplated in Articles 81 and 86 of the Constitution. It is a backdoor amendment to Articles 86 and an unjustifiable variation to the jurisprudence of the Supreme Court on Section 83 in Raila Odinga 2017. It also seeks to validate minority over majority holding over the issue. A principle developed in deference to the separation of powers, and more specifically in the light of the role of Parliament under Article 94 of the Constitution, is presumption of constitutionality. Any legislation of Parliament is presumed constitutional, and the burden is on the person challenging the legislative act to show what manner it breaches the Constitution. This principle has been resounded in numerous decisions of the High Court, including Mugambi, Imanyara, and another, and the Attorney General. It is not apparent, either from this case by the petitioners by way of rebuttal of the presumption of constitutionality or following the application of the law, that the same violates the Constitution and more specifically fundamental rights and freedoms. As such, the constitutional qualification against the presumption in strict terms of Article 2 of the Constitution does not arise. I must, however, add that the finality of the Supreme Court as a judicial agency and its role as the custodian of the Constitution militates, save for rare instances dictated by circumstances of each case, against the blanket presumption of constitutionality without delving into holistic interpretation of the constitutional vis-à-vis impugned law or conduct. The judiciary in general and the Supreme Court in particular retains control over the interpretation of the Constitution. The petitioners claim that the amendment compromises the independence of the judiciary. Attempt to review this court's determination in Raila Odinga 2017. The legislative authority of the Republic is vested in Parliament. Parliament is the only body with powers to make provision, having the force of law, unless otherwise provided by the Constitution or legislation. Therefore, at the onset, by enacting the Election Laws Amendment Act, Parliament was well within its constitutional mandate. It was also urged that the legislative process was hasty, devoid of public participation, and ignorant of the views of other important stakeholders. It is admitted that on the 2nd to 5th October, the Joint Select Committee of the National Assembly and Senate Committees on Election Laws put in place avenues for public participation from different stakeholders through the submission of proposals. This fulfilled the requirements of public participation under Article 118. Was the amendment to Section 83 of the Elections Act to undermine the independence of the judiciary? The purpose of the Elections Act Amendment Law was elaborated by Honorable Cheptumo while moving the Election Laws Amendment Bill, reading for a second time in the National Assembly. And I quote from the Hansard of the 12th Parliament of the 10th of October 2010. I'll not read all of it, but just read excerpts. Honorable Cheptumo speaking. Thank you, Honorable Speaker. I beg to move that the Elections Law Amendment Bill be read a second time. The bill I have sponsored also seeks to align the Elections Act with the I have referred to, and in effect align the Act and with relevant provisions of the Constitution. Close reading of election-related laws reveals that where there are gaps in the law, and indeed many and variant interpretations depending on the number of lawyers interpreting them. This is a highly litigant country where every Kenyan lawyer will have interpretations of various situations and laws. Therefore, the bill proposes specific amendments to fill existing gaps in our scheme of laws and may lead to a legal and constitutional crisis if not addressed prior to the conduct of fresh elections. I wish to inform the nation that we received views from all sectors of our society, and that Kenyans took advantage of public participation to come forward and give their input. Honorable Speaker, allow me to move to the specific clauses of the bill. Clause 9 of the bill seeks to amend Section 83 of the Elections Act. This section was the focus of the presidential election. What we are saying here is that Section 83 has two aspects. One, in an election petition, it is the business of the petitioner to establish one aspect of that section. The second aspect is about showing the non-compliance with the Constitution and indeed substantially affected the results. The problem with ambiguous laws is that they are subject to interpretation by different people. We want the law to be clear. In our region, the same provision as proposed in the amendment bill is in use in Nigeria, Ghana, Zambia, Tanzania, and Uganda. I cannot explain how we did not provide for our laws to be realigned in that manner. What now is for this House to make a decision and to amend our laws. End quote of the Hansard. The Constitution organizes the functioning of the state in three distinct arms of government: the legislature, the executive, and the judiciary. Each of these entities has powers meant to protect the Constitution and sovereignty of the Kenyan people. It does not, however, follow that when one arm exercises its authority, that authority automatically undermines the functioning of the other. In this case, Parliament did make reference to the court's interpretation of Section 83 in both the majority and dissenting opinions, and sought to clarify the law by legislation. The above provided as Hansard experts guide my consideration of the purpose and effect of the legislation. I am persuaded that Parliament was in no way invasive into the judicial realm in amending the impugned section. The purpose of the legislature was to clarify the law and to bring into conformity with international best practice. I hasten to add that a law does not become unconstitutional simply because it goes against the precedent of this court or other courts. This legislative mandate affords the opportunity for courts to reconsider precedent and nurtures the development of constitutional law. Finally, to the question: does the disjunctive approach of amended Section 83 violate the principles in Articles 81 and 86? Article 81 outlines the principles of the electoral system. Article 86, on the other hand, provides the imperatives of voting, voting method, counting, tallying, announcement, and post-election safeguards. These principles are therefore cross-cutting. A strict dichotomy, of which I am in favor, would separate these two principled provisions on the bearing of process and outcome. These two critical elements of an election are crucial in the determination of its validity. The process gives rise to the outcome. Therefore, deviation from the process must be considered against its effect to the declared outcome. In this court, in Peter Munya and others, emphasize that the Elections Act and regulations thereunder are normative derivatives of the principles embodied in Articles 81 and 86, and a court of law cannot disengage from the Constitution while interpreting them. Section 3, as amended, provides a formula for evaluating the conduct of an election against the process and outcome, and is the product of Article 82 of the Constitution. It does not take away the powers of an election court to determine the compliance of an election with the purpose and principles of the Constitution. As such, I find no persuasion in the claim that it is inconsistent with the Constitution. I conclude by the following. Section 83, as amended by Section 9 of the Election Laws Amendment Act, is the law applicable for the determination of this petition. Section 83 also provides the determining formula to this election court adjudicating the election cause, and as such, it also the applicable law in other pending election causes before lower courts. The question of consistency of Section 83 with the Constitution is distinctive to that of the other provisions of the same amendment laws. Section 83 does not follow the electoral event, as does the substratum of the other provisions. Section 83 follows the declaration by the judicial officer. I find no persuasion in the impugned provision, its purpose and effect, or the conduct of the legislature, and the issue therefore ought not to be retried by the High Court.
Thank you, Justice Njoki. It's now my turn to read the judgment on the remaining issues, which are was the election held on the 26th of October 2017. It's legitimate and credible, both in fact and in law. And then finally I will read the orders, the final orders of the court. On the issue of legitimacy and credibility, the petitioner submitted that the election held on the 26th of October 2017 lacked legitimacy and credibility. The second and third petitioners in particular argued that the election was not conducted in a conducive environment, that many voters were disenfranchised, and that the low voter turnout was a manifestation of a low quality election that was defective on all fronts. In analyzing this issue, we will begin by understanding the meaning of the terms legitimacy and credibility. Concise Oxford Dictionary defines the term legitimacy as being able to be defended with logic and justification. This is a broad yardstick which essentially concerns propriety or lack of it. In analyzing this or examining this concept, we have also scholarly work that has dealt with it, and in particular we have looked at the article by Professors Patrick Maslin and John McElderry in an article entitled Law, Legitimacy and the Constitution, Essays Making the Centenary of Dicey's Law of the Constitution, and where he states that a claim to political power is legitimate only when the claimant can invoke some source of authority beyond himself. They further state that an institution is legitimate when it corresponds to the dominant doctrines of a period, to the most widely held beliefs on the nature and the form of the power. Credibility, on the other hand, is defined by the Black's Law Dictionary as the quality that makes something worth of belief. The issue then comes is credibility in whose terms. We take the view that the term must be measured in the eyes of the general population, for whom dependability and sustainability are all important on a day-to-day basis. Indeed, the rationale of the electoral process is that it should facilitate the dependability of governance for the voting public. Though the test is largely subjective, the court's task is to rest its finding its classical yardsticks of legality, rationality, and objectivity, being guided by its true professional understanding of the public interest. In this regard of legitimacy and credibility, the petitioner's case is that there was widespread violence occasioned by the state, and that and there was also intimidation, which put off the voters from the polling centers. They also alleged that citizens in some constituencies directly prevented voting by other citizens by blocking the roads to the polling stations. How do such factors feature in the credibility profile of the in the nation at large? The second and third petitioners also contend that the election of the 26th of October fell outside the principles stipulated in Article 81 of the Constitution, which is concerned with free and fair elections. They thus contend that the election was not free from violence, intimidation, improper influence, or corruption. They have given instances of intimidation, which just Wanjara led earlier on as a judiciary, threats occasioned by the Jubilee Women Brigade, and threats from some men wearing a military uniform. The second petitioner further claims that the election process was affected by riots and security officers in polling stations like Kibra, Siaya, Homa Bay, Kisumu, and Migori. So they contend that the election was not held in a conducive environment, and as such, it cannot be considered as a legitimate or a credible election. The other ground upon which the petitioners challenge the election on the issue of credibility and legitimacy is the one of low voter turnout. They argued that because of the violence and the intimidation, and to some extent because of the boycott, the election of the 26th of October 2017 was the lowest, attracted the lowest voter turnout in the history of this country. So they urged that we nullify the election because it was not credible. The respondents, on the other hand, argued that repeat elections generally have low voter turnout. They have given instances in Kenya of a repeat election in 2013 in Makueni, where the initial election attracted 84%, but the by-election that was held attracted 24%. And they have also given several instances, instances like in South Africa. They have given instances in the US. They have given instances of Mauritania. They have given instances of Germany, Switzerland, France, and Zambia. In particular, they argue that in France, in the general election held on the 23rd of April 2017, there was an estimated voter turnout of 78.69%. While the second round of elections attracted a turnout of only 38%. In Zambia, where the registered voters in an election held in 2015 was 5,166,084, in a repeat presidential election, only 1,671,662 turned out, representing a voter turnout of only 32.4%. So the argument is that voter turnout cannot be a criterion for determining the legitimacy or credibility of an election. So the argument is that there was no widespread violence in the country, such a low voter turnout that the election could not be classified as legitimate and credible. That then now brings us to the issue of, our determination of whether or not the election held on the 26th was credible and legitimate. Thus, in addressing credibility in the context of the Imband election, among other things, the court must adhere to the verifiable criteria, such as, was there preparation for the election? Did the election take place? Was the conduct of the election guided by the prescribed law? What scope of discretion existed within the law? Was this duly exercised? Was a candidate duly declared elected? In general picture, was the constitutional task accomplished? On that criteria, you could also ask the issue of whether the election was conducted by the body constitutionally mandated to conduct the election, that's IEBC. Was the election held, or it failed, or it simply failed? Was due procedure followed? Were any false results announced in place of the true results? That the voters turned away from the polling station by IEBC, by any state agencies? When you take all these factors into account, you reach the conclusion that the body entitled to conduct elections, that is IEBC, conducted the election. It did not turn out any voter. No state agency hindered the voters from voting at the polling stations. So in the circumstances, you also now have to consider whether Article 81 of the Constitution, which requires the election to be free and fair, free from violence, and whether or not it was transparent and efficiently and accountably conducted, we've come to the conclusion that the election was free and fair and transparent, and that, and more importantly, that the ultimate yardstick for determining the winner in the presidential election, as provided by Article 138(4) of the Constitution, in the following terms: be declared elected as the president if the candidate receives more than half of all the votes cast in the election, and at least 25% of the votes cast in each of more than half of the counties. In our consideration, we find that all these, the threshold was met, and that the election was free and fair. There is the issue of, we want to say something about the issue of legitimacy. It has tended to be appreciated quite objectively that the voter turnout in the repeat election in general was low. Although there were a myriad of factors in the present case, that led to the low voter turnout in election. An election cannot be tainted solely on the ground of lower voter turnout. This is because of, as we have found, voter fatigue and the general apathy that attends to repeat elections or by-elections. The factors that led to lower voter turnout, although politically tainted, the inviting political solutions are not sufficient in the instance case as a basis for banning the general election. The conclusion we reach, therefore, is that the election held on the 26th of October 2017 was credible and met the constitutional threshold that is required of a presidential election. Having reached that conclusion, and other parts of the judgment that have been read by my colleagues, we find and make the following orders. That petition number 2 of 2017 by John Aaron Mwau versus Independent Electoral and Boundaries Commission and the 2 others, as consolidated, is hereby dismissed. Petition number 4 of 2017 by John Jomue and another versus IEBC and the 3 others as consolidated is also dismissed. As a consequence, the presidential election of the 26th of October 2017 is hereby upheld, as is the election of the 3rd respondent. The issue then we want to tackle is what orders we should make with regard to costs. As we had stated in the RAIRA 2013 and the 2017, issues of election petitions, which are in most cases matters of great public interest, it is imprudent to award costs against the losing party. In this case, we also find that this was a matter of general public importance, and we award no costs. The order on costs is that each party bears its own costs. Thank you very much. That is the judgment of the court.
Most of them.
Most of that. Maybe, my Lord, the Chief Justice, for the record, when we introduced ourselves, my sister Julie Soweto and Bobby, my brother Bobby Opolo had not come. They may go on record as being representing the 4th, rather the petitioners in the petition number 4. Yes. Thank you. And Mr. Oiko has something to say to court.
My Lord Chief Justice and judges of the Supreme Court, just wanted to raise or bring to the attention of the court one issue that may require just some expounding, and maybe it's in the all clarification. I happen to be in petition number 548 of 2017. I'm prosecuting that petition on behalf of the petitioners. That is the petition of Katiba Institute and 3 others versus the Attorney General and one another. The one other is the National Assembly. We were to be heard on that petition on 5th of December this year. However, the National Assembly applied for an adjournment on the basis that this court was rendering itself today, and we've been asked to go for the hearing the day after tomorrow, the 13th. I had Justice, first of all, I had your Lord Chief Justice say that Justice Joaquin Dungu's opinion is concurring. And in her opinion, she did state, in your opinion, maybe if I may start with the court opinion, the court refused to answer the question of whether Section 83 is unconstitutional. But in her opinion, in my understanding, she did answer that question, but more critically, and this is why I'm seeking your clarification, she did, if I heard it correctly, that the issue of Section 83 should not be retried at the High Court. And I stand to be corrected. I know when I go on Wednesday, then that issue will come up. And I'm not in a position then to know or to clarify whether then the judge should take jurisdiction. And this is the danger. If the judge doesn't take jurisdiction, then that issue will never get up here, or at least that's my fear. So I don't know whether the court is in a position to clarify for us on that issue, because in my view, it really impacts on rights issues that we've raised in the Supreme Court. Thank you very much. Sorry, at the High Court actually, because that's where the litigation is happening. Thank you.
We don't want to steal the expression of the High Court. What we have stated in the majority judgment here is that law applicable as at the 26th of October was the law as it was before the amendment. Judge Njuki has a different view, and we couldn't make a concurring opinion because she concurs with the final judgment of the court. But she has her own view. Sorry, she has her own view that Section 83, as amended, should be the one applicable. So, I mean, that is the position of the court, so it has to be left. And I believe when the matter will be determined, the High Court will have read this judgment in full, and it will be able to decide the matter without any...
That's fine, I believe.
Yes. So thank you very much, Counsel. Thank you very much for... Sorry?
The Honorable Chief Justice, sir, I'm Justice, and I'm an independent counsel. I indeed wish to know if you received my petition on behalf of the independent. 2017 and one on 26th, the 26th of October. All were in letter from about the elections.
Did you file the petition in the registry?
No, I submitted them to your secretary, to your office.
Yes. By letter? Is a letter to
you in person.
Yes?
Yes. Letter forms, but they were petitions.
They were petitions.
And I'm pleased about you, for you have given me this chance
Yes.
to address you.
What you said your name is?
Abdurrahman Charlie.
Yes, Abwana Abdram.
Born of the coast, but I was brought up.
Very well. Abwana Abdurrahman, listen to me. Abwana Abdurrahman, the law requires that if you want to challenge a presidential election, you file a petition in court, you pay a deposit, then the petition is heard. If you don't, wait, let me explain. If you don't have money, you make the application well in advance, and the court considers whether it can allow you to file a petition without paying the required deposit and the required fees. When the court has allowed you, then it will look at your petition. Yours, no, I don't want to make this an argument.
The constitution mandates one can submit in letter forms. It doesn't have to be in any form of documentation. So it compels me to write on materials. So
Yes.
someone has to give justice.
Yes. Very well. The letter will be responded to.
Before I finished, there was an incentive of the Jubilee president being elected. I don't think so. You see, 2013, 2017, the independents had been excluded in the election.
Very well. That is okay, Mr. Abdurrahman. We are not going to sit here. No. We will not allow you to tell us what you think should have been done. We have told you if you wanted to file a petition, you should have filed it in the form of. You did it.
But did you receive?
Now to my office and my secretary will check whether or not it was received. Thank you.
Muktasari ni kuwa mahakama imerejelea uamuzi ambao ilikuwa imetoa siku